Private Wealth Services Group at Gunster, and we're so pleased that you're all joining us this afternoon. We realize that we're all experiencing a new normal. We're navigating uncharted waters, but history has taught us that the world will recover from COVID-19, but not without significant impact on our lives, the lives of our family, the lives of our friends, the world, and the U.S. markets. The recent increases in gift and estate tax exemptions, coupled with a decline in asset values and reduction in interest rates, all due to the pandemic, make this an ideal time for high net worth individuals to implement a wealth transfer strategy, including an evaluation of the aspects of any existing plans that you may have. Today, we'll be addressing the gift, estate, and charitable planning opportunities, as well as recent immigration and employment changes which affect high net worth individuals. But first, before we begin, a few housekeeping points. We are recording this webinar. You can review a replay on demand from Gunster's COVID-19 website. It will be posted tomorrow morning, so please feel free to share it with others. You can find additional timely information and resources there as well. Go to gunster.com/COVID-19. At the end of the presentation, we will have time for questions, so I encourage you all to submit any questions you may have using the Q&A feature on your screen. Questions will be sorted, read aloud anonymously, and answered by the most appropriate speaker. We have also created a dedicated COVID-19 email inbox that we monitor regularly. So after this webinar, you can email us at covid19@gunster.com, and we'll be able to return any answers to any questions. Now let me take the opportunity to introduce our speakers today. I will first be joined by Elaine Bucher. Elaine is a shareholder currently serving on our board and resides in our Boca Raton and West Palm Beach offices in our Private Wealth Services Group. Elaine and I will be speaking on about 6 different estate tax reduction techniques which are particularly effective in a low interest rate environment. I will then hand over the presentation to Gunster shareholder Adi Rappoport. Adi co-chairs our tax practice group out of our West Palm Beach office, and Adi will speak about charitable planning in a COVID environment. Closing up our presentation will be Gunster shareholder Sarah Tobocman, who chairs our immigration practice group out of Miami, and Gunster shareholder Holly Goodman of our labor and employment practice out of our West Palm Beach office. Sarah and Holly will speak about the immigration and employment issues affecting high net worth individuals, including domestic and professional staff and family employees in the new COVID-19 environment. Let me now turn your attention to our screen. We have a few slides for you this morning. We'll first talk a little bit about the 6 estate tax reduction techniques: grantor retained annuity trust, gift sale to intentionally defective grantor trusts, substitution of assets with grantor trusts, interfamily loans, renegotiation of existing loan interest rates, and Roth IRA conversions. But first, let's talk a little bit about some basic gift sale concepts that we all need to know. Current gift and estate tax exemption is $11 million per donor. It is $23,160,000 if you're married. It's scheduled to revert back to the prior exemption of $5 million indexed for inflation as of January 1, 2026. Unless you use the additional exemption, you will lose it. Since the exemption can be reduced by next year, depending upon the election and other variables, most advisors are recommending that clients consider some of the techniques that we'll discuss today. Current fair market value of gifted assets determines the use of your lifetime exemption. Gifting reduced valued assets allows for transfers at a low tax cost and appreciation to escape taxation in a donor's estate. So let's talk about the first technique, which is a GRAT, a grantor retained annuity trust. In a GRAT, assets are contributed to a trust to provide for an annual annuity payment to the grantor for a fixed number of years. The annuity amount is generally a fixed percentage of the initial fair market value of the assets being transferred to the GRAT. And the GRAT can provide for annuity amounts with an increase as much of 20% a year over the trust term, which would allow for more growth. It's paid regardless of the amount of income generated and whether the trust assets rise or fall. At the expiration of the term, the trust assets will pass to the ultimate beneficiaries of the trust, who are typically children and maybe other family members. And when structured properly, the GRAT will pass all future appreciation of the transferred property with little to no lifetime exemption used. Because of the low interest rate environment and the down markets, the benefits of establishing a GRAT are magnified. The current 75/20 rate, which is the rate used, is only 0.8%. So what happens if the grantor dies prior to the end of the term? Well, the annuity will continue to be paid to the grantor's estate. The value of the assets in the GRAT will be subject to estate tax, and the grantor's estate will receive a credit for any gift tax already paid. But as we said before, we don't expect there to be any gift tax paid. The bottom line, although the tax advantage that the GRAT was designed to achieve is lost, the grantor's estate will be in the same position had the GRAT not have been created in the first place. So what about the income tax consequences? Well, during the GRAT term, the GRAT is a grantor trust for income tax purposes, which means that any income is taxed to the grantor. Any continuing trust for a spouse or children could also be structured as a grantor trust, and therefore the individual can continue to pay the income tax. The payment of the trust income is essentially an additional tax-free gift to the beneficiaries of the trust. The taxes, although the GRAT continues, it's based on the 75/20 rate. The 75/20 rate is actually the applicable federal midterm rate. In order for the GRAT to be successful, you have to have assets that appreciate greater than the midterm rate, which is currently 0.8%. The most popular form of a GRAT is a zeroed out GRAT. The term is limited usually to 2 or 3 years, and the annuity amount is maximized in order to produce the smallest taxable gift as close to zero as possible. The anticipated short-term growth in the trust assets can be availed without the risk of any long-term uncertainty, if you do a 2 or 3 year GRAT. So how does a GRAT work? Well, if you look at the depiction on the screen, you'll see it's pretty simple to set up. The assets get transferred, the annuity payments go back until the expiration of the term, and the remaining assets pass to the grantor's children. Quick example, if you give $10 million to a 2-year GRAT with a 20% increasing annuity payment at the midterm rate of 0.8%, growth of 4%, you see the 2 annuity payment amounts that are made over the 2 years. The balance to the family is over $500,000 that escapes the state tax in the grantor's estate. If discounts are taken on the value of the assets going into the GRAT, there's additional benefit to the family. And if the grantor pays the income tax, in this situation, it would increase the benefit to the family to over $740,000. So the GRAT is a very, very compelling tool in a low interest rate environment. I now hand over the slides to Elaine, who's going to talk about intentionally defective grantor trusts. Elaine? Elaine, can you hear us?
Sorry about that, technical difficulties. You heard Lisa talk a little bit about grantor trusts in the context of GRATs. I'm just going to talk a little bit more about intentionally defective grantor trusts, what they are and how they can be used. A gift coupled with a sale to an intentionally defective grantor trust is essentially used to freeze the value of your estate. And this is how it works. First, you create an irrevocable trust that is a grantor trust for income tax purposes. Everybody loves when they hear the term defective in the name of their trust, but it's really not a defective trust. It's only defective for income tax purposes, meaning that the income is taxed to the grantor, which is actually a benefit. And we'll see how in a minute. Then, after you create the irrevocable trust, you fund the trust with seed money that's equal to 10%, at least 10% of the value of the property that will be sold to the irrevocable trust. Now, with the increased gift tax exemption, as you heard, of $11.58 million, that's a significant amount that can be gifted to the irrevocable trust. After the gift is done, you sell assets to the irrevocable trust in exchange for a promissory note. And the promissory note is going to bear interest at an incredibly low rate right now, which is one of the reasons that this really makes sense in a low interest rate environment, because you are selling and transferring assets. You're selling assets to a trust. You're taking back a promissory note. If it were a 9-year note and you sold assets this month, the rate would be 0.58%, which is as low as we've ever seen it. So basically, the assets just need to appreciate at a rate more than 0.58% outside of your estate for this to make sense. And as an added benefit, if you're married, your spouse can be a beneficiary of this intentionally defective grantor trust. So here's a picture that basically summarizes how the transaction works. Grantor transfers what we hope will be highly appreciating assets to the trust. Grantor takes back an installment note, can be paid interest only each year at a very low rate right now, and can be paid back at the stated term in the note, typically 9 years. And the trust is for the benefit of children, grandchildren, future generations, as I mentioned, can be for the benefit of a spouse. And all of the appreciation inures outside of the grantor's taxable estate. So huge benefit there. Here are just a summary of the benefits. The transaction should remove from the grantor's estate all appreciation on the assets after the sale. If the asset is basically a minority interest in an entity, it could be a family limited partnership, it could be a closely held corporation, an LLC, a discount should apply on the sales price. A discount somewhere between 30 and 40% typically, as determined by an appraisal, is what we're seeing. In addition, the grantor can allocate GST, generation skipping transfer tax exemption, to the gift made to the trust. The sale is fully GST exempt, and GST exemption does not need to be allocated. Because the trust is a grantor trust for income tax purposes, there are no capital gains tax due on the installment sale. The interest income on the note is not taxable, and the grantor gets to pay the tax on the trust income. And I say gets to pay because essentially that's another way for the grantor to get assets out of his or her estate without that payment being a gift. I've included an example of the gift sale to the intentionally defective grantor trust for your reference, but no need, I'm not going to review it right now, but it's there in the event that you want to take a look at how it works. What I will do, anticipating the question of what works better, an intentionally defective grantor trust sale or a GRAT. Now, there's pros and cons of each technique. One of the benefits of a transfer to an intentionally defective grantor trust is that there's a lot of flexibility. The sale can be done for a balloon note. There's always the possibility of an early payment of the note if the grantor wants the liquidity. And there are note refinance opportunities, as you're going to hear in a minute from Lisa. In addition, there's less estate tax inclusion in the event of an early death of the grantor. Essentially, only the value of the note, the balance of the note, would be included in the grantor's estate. And a huge benefit of this transaction over the GRAT is to maximize use of the GST exemption. So what are the benefits of the GRAT? One of the biggest benefits is it is not risky in that the GRAT is contemplated and set forth as an accepted technique in the Internal Revenue Code. A second benefit is that basically you can form a GRAT without using any of your gift tax exemption. And that is certainly a huge benefit for people who have already used their gift tax exemption and don't want to pay gift tax. And the third benefit is typically there's less administration on the back end. Now, let's talk about the third technique. And this is a pretty simple one. It's basically substitution of assets with the intentionally defective grantor trust. Now, there are various ways that estate planning attorneys can make the trust a grantor trust for income tax purposes. One of the most common ways is the use of a substitution or swap power, meaning the grantor retains the ability to swap assets out of the trust in exchange for other assets of equivalent value. Now, one of the benefits to using that swap power is if there are low basis assets in the intentionally defective grantor trust, and the grantor has higher basis assets in his or her name, he can swap out the assets to get the higher basis assets in the trust, take out the low basis assets, so that when he or she dies, the assets will get a step up in basis because they were in his or her individual name. In addition, this can be used to swap out assets with a higher appreciation potential for assets that have already run their course in terms of appreciation. So it does add a lot of flexibility after the transaction is done if the grantor wants to swap out assets. And with that, I'm going to turn it back to Lisa to talk about the next strategy.
Thanks, Elaine. Well, the next strategy that we're going to talk about is, I think I skipped a few, there we go, interfamily. So in contrast to a bank loan, where creditworthiness of a family member borrower is important, it can be essentially overlooked in the case of a family lender. The IRS allows family loans to use the applicable federal rate, or the AFR, as the interest rate. So the short term, there's a short-term, mid-term, and long-term rates. Short-term would be 0 to 3 years, mid-term 3 to 9, and long-term over 9 years. As I said before, the current May mid-term AFR rate is actually 0.58%, incredibly low, the lowest that I've ever seen. A family loan can be used for any purpose. It could be used to pay down a child's mortgage. It could be used to make investments at higher interest rates. It can provide capital for a startup, or even loan the money for family purchases. It could be used for education. There's many different reasons that money can be loaned to family members, and it doesn't need to have a business purpose. It doesn't need to have a business reason. You can just loan the money at the AFR rate, but and that basically by IRS standards would make it it's a family loan, but yet it's treated as respected for IRS purposes. There are also low transaction costs in making family loans. Security can even be taken without an appraisal. It's up to the lender. And there are no closing costs other than maybe a mortgage recording fee if you're going to take a lien on a piece of real estate. The transaction is simple. It's an easy way to transfer money to the lower next generation, so they can take that money and invest it at higher rates or use it for other purposes. Needs to be obviously evidenced by the proper paperwork and respected, and no payments made. But it's one that is not only easy to accomplish, but can be very rewarding as you can watch where the money goes. The next topic that I'd like to talk about is the renegotiation of existing loan interest rates. So here, if there are any loans that have been previously made, and it may be to family members or closely held businesses or trusts, And as Elaine discussed, assets can be sold to a defective grantor trust for a promissory note. There are many transactions that were entered into when the rates were high, and certainly higher than they are today. And there are a lot of promissory notes that are sitting out there just ripe to be renegotiated. As stated, the May's AFR for a midterm rate is only 0.58%. The long-term rate is only 1.15%, incredibly low. So now's the time to look at refinancing those older promissory notes, and maybe those executed even as recently as this past December through January or March, before the rates before all the rates started dropping and the pandemic was in full swing. Reducing loan payments will allow trust assets to grow faster and reduce assets flowing back into the grantor's taxable estate. Lower payments may mean a reduced need to sell assets in a trust to raise liquidity, especially in a down market where the assets' value are lower and you'd prefer to hold on to them and let them recover. And it would also, in many instances, perhaps avoid a risk of default on the promissory note. There does need to be consideration for the renegotiation of the note. It may be a partial payment a down payment of principal. It may be a reduced term of the loan. It may be additional trust funding. It may be third-party guarantees. It could be additional security being offered from an outside source. But again, it's somewhat simpler than some techniques. And if those notes are out there at very high interest rates, the benefit to the growth of the assets that you've transferred can be pretty substantial, as we're seeing right now. So and I now will turn it back over to Elaine, who's going to talk a little bit about Roth IRA conversions. Elaine?
Thanks, Lisa. So this is the last technique on the estate planning side that we'll be talking about today, but it's an important one. And really, it falls down to conversions of Roth IRAs, conversions to Roths from traditional IRAs. Owners of a traditional IRA have the ability to convert all or a portion of their IRA to a Roth. The account owner has to pay income taxes on the pre-tax contributions, and the earnings get rolled into the Roth IRA. Now, Roths can provide two important advantages over traditional IRAs. One is that no income tax is imposed on future withdrawals. And the second is no required minimum distributions need to be taken during the account owner's lifetime. And although the ability to contribute to a Roth is phased out for high income taxpayers, there's no income threshold test for conversion of assets from a traditional IRA to a Roth. And so in a depressed market, this could be the time to evaluate whether a conversion makes sense for you. One, the cost of conversion can be lower because asset values are lower. And two, when the market rallies, growth is in the Roth IRA, and distributions from the Roth, as I mentioned, are tax-free. And so this is a time to be evaluating whether that makes sense. Of course, all factors need to be considered. Current and future income tax rates is a big one. If you're at a higher income tax rate now than you anticipate being, it might not make sense. If you don't have available liquidity to pay the tax on conversion, it might not make sense. But certainly makes sense for consideration in the depressed market value that we're going through. And with that, I'm going to turn it back to Lisa to introduce our next speaker.
Terrific. Thank you so much, Elaine. Appreciate all of you doing there. So now I'd like to turn our attention to Adi Rappoport. Adi is going to talk about the CARES Act provisions impacting charitable giving, some charitable strategies in a low interest rate environment, charitable lead trust, and the Secure Act and charitable giving. Adi?
Thank you, Lisa, and good afternoon, everyone. I will first address the CARES Act. The CARES Act was the second round of stimulus that Congress passed in response to the coronavirus pandemic. This was enacted back in March, and there's a lot of features of the act, many of which have been in the news, including the PPP program. but there are also tax and charitable changes that were made in the Act, one of which is the suspension of the AGI limitation on certain cash contributions to charities. So many of you may be familiar that when you make a charitable contribution, there are limitations depending on the type of charity you make the donation to. So it could be a donation to a public charity or a private foundation. There's also limitations depending on the type of assets you make, if they're securities or inventory, for example. Back in 2017, the Tax Cuts and Jobs Act created a 60% AGI threshold for gifts to charities other than supporting organizations, private foundations, or DAFs. And so what the CARES Act did in March is increase the AGI limit from 60% to 100% for certain qualified contributions, which means you can use a charitable contribution in 2020 to completely offset your taxable income and reduce it to zero. It's a very powerful tool for people who are charitably inclined. What is a qualified contribution that would be eligible for this treatment? It must be paid in this year, in 2020. It must be made to a 501c3 public charity. So it can't be made to a private foundation, it can't be made to a supporting organization, and cannot be made to a DAF. The taxpayer has to make an election for this benefit to apply. And if you're a partner in an S corp, or a partner in a partnership, or a shareholder in an S corporation, you make that election in your capacity as an owner, not on the entity level. And it's important to note that the donation does not need to be made to a public charity for a COVID-19 purpose. So it can be made to any public charity. One thing, if you're going to pursue this strategy, is you want to make sure you make the deduction or the contribution after taking into account all of your itemized deductions, for example, state and local or mortgage interest. That way, this would avoid you inadvertently creating a net operating loss. Earlier, moments ago, Elaine talked about using a Roth IRA conversion strategy. And so one thing to think about, if you're inclined to convert from a traditional IRA to a Roth IRA, and if you're charitably inclined, you could make a charitable contribution and completely eliminate the adjusted gross income created by your Roth IRA conversion and have no income tax in the year of conversion. So if you are someone, you have a client that was looking to make a sizable charitable gift, or they have a pledge that is going to be made over a number of years, consider whether you want to accelerate that obligation and couple it with a Roth IRA conversion. The other slight change in the CARES Act is a $300 above the line deduction. So if you do not itemize deductions, you can deduct a charitable contribution up to $300 above the line. The next thing I want to talk about is, again, strategies you can use in a low interest rate environment. Lisa spoke about a grantor retained annuity trust, a GRAT, and there's a charitable variation called a charitable lead trust. And based, again, on the low interest rate environment, it's a strategy you could consider if you are charitably inclined. So the charitable lead trust works very similarly to a grantor retained annuity trust, except the annuitant is a charity, not a individual. And so there's some things you need to consider in designing the CLAT. You have to make some decisions, whether the annuity will be for a term of years or for the lives of individuals, how to fund the CLAT, whether it's going to be with cash, securities, or other assets. Like Lisa said, if you use discounted assets like a family limited partnership, you can further bolster the leverage you get out of the strategy. Typically, you would zero out the CLAT the same way you would a GRAT, so there's no gift to the remainder men upon formation. And essentially what you're doing is you're creating an annuity for a charity, and any appreciation above the hurdle is going to your family members. And so in an environment where the hurdle rate is 0.8%, then consider whether you think your investments will outperform that hurdle rate. And if they do, you can both zero out the gift, so there's no transfer tax on creation of the strategy, and you are likely going to be able to provide some significant value to your family members. One thing to consider if you have a private foundation is that the private foundation can be the annuitant, the charitable annuitant, and there's some other decisions to be made from a planning perspective. For example, whether you want the CLAT to be a grantor trust CLAT or a non-grantor trust CLAT. And so the decision you would make there depends on whether you want to get a charitable contribution deduction for the value of the transfer that is going to charity. Finally, I would like to discuss the Secure Act. The Secure Act was enacted in December 20th, 2019, and until the COVID-19 crisis, that was the biggest headline news in estate planning. What the Secure Act did was significantly modify the way retirement plans work, and the key features of the Secure Act are that the minimum age for required minimum distributions was raised from 70.5 years old to 72 years old. It allows workers to contribute to IRAs after turning 70.5. It allows individuals to use 529 money to repay student loans. It makes it easier for 401k plan administrators to offer annuities, but the one that got the most attention is eliminating the stretch IRA by requiring non-spouse beneficiaries to take out minimum distributions over a period of 10 years. And so in terms of charitable planning, I want to point out two things in light of the Secure Act. First of all, many of you know that even prior to the Secure Act, you could roll over up to $100,000 each year to a charity out of your IRA. The Secure Act now provides that if you make contributions to your IRA after turning 70.5, the amount of qualified charitable distributions you can take are reduced by the contributions you make under 70.5 after you're 70.5. So if you're charitably inclined, you may want to consider whether you want to make additional contributions after you turn 70.5. Second of all, you can roll over $100,000 a year to charity starting at 70.5, even though you don't have to start taking distributions until you turn 72. So there's a gap period. From a planning perspective, if you're charitably inclined, you can start making charitable distributions from your IRA before you have to take required minimum distributions. And the opportunity is that your required minimum distributions would be diminished because you lower the value of the account. The last item to consider is there's discussions and considerations of using a charitable remainder trust to stretch an IRA beyond the 10-year period that's permitted for non-spouse beneficiaries. The planning works is that you would set up a charitable remainder trust during your lifetime, and you would name that the beneficiary of your trust. The charitable remainder trust would pay an annuity to the annuitants, and the remainder would go to charity. There's a requirement at funding that at least 10% go to charity. And so that's something to consider if you're interested in a stretch situation where the law otherwise wouldn't allow it, and you're also interested in making a transfer to charity. Back to you, Lisa. Thank you.
Thanks so much, Adi. Appreciate it. Now I'd like to turn the presentation over to Sarah Tobocman. Sarah is going to talk about some restrictions on international travel due to COVID-19, the impact of COVID-19 on foreign nationals, and how specific foreign nationals in the United States deal with the immigration process and how it's affected. First, I just want to note as well, there's been a question about a recording. For those of you that are interested, there will be a replay of the presentation today, and you can access it through our website. Tomorrow morning, it should be at gunster.com/COVID-19. Sarah, to you.
Thank you, Lisa. In Gunster's Immigration Practice Group, we assist U.S. employers, including family offices and their principals, to craft solutions to obtain work authorization for family office employees and domestic house staff, and we advise and train on procedures to maintain a legal workforce. On the U.S. immigration front, the COVID-19 pandemic has resulted in many new restrictions affecting entry and travel, as well as some temporary policies that have provided needed flexibility for people that are already here in the United States and are having trouble departing the U.S. because of the pandemic. Now, even if you were born and raised in the United States, it's likely that these issues may touch on somebody in your sphere. It may be friends or relatives in the United States as tourists. It could be domestic house staff, au pairs, yacht or aviation crew, or professional employees sponsored for work authorization at your family office. So let me give you a brief overview of what's going on. First, let's talk about the restrictions on international travel due to COVID-19, both entering the U.S. and traveling to other countries. And then we'll talk about what's going on for people who are here in the U.S. and are potentially having a hard time departing, and then what's on the horizon. All in all, there have been 5 proclamations issued by the president relating to entry in the U.S. since the COVID-19 pandemic. Now, the first 4 of these have focused on people who are viewed as posing a risk of transmitting the novel coronavirus based upon the regions where they've been physically present in the 14 days before they seek entry to the U.S. So these include China, Iran, the Schengen region of Europe, which is 26 countries in Europe, the UK, and Ireland. Now, there are exemptions, and generally these exemptions include U.S. citizens, lawful permanent residents, such as that's more commonly referred to as green card holders, their immediate family, air and sea crew traveling to the U.S., so that would be pilots and from private planes potentially, and those on private yachts, and several other classes of people. Now, the Fifth Proclamation, which was issued on April 23rd, has a much different tenor than the first 4. The fifth one is really oriented, as many things are now, on reopening the U.S. economy, and is targeting immigration in a way to say that how can we protect our U.S. workforce? How can we stimulate our U.S. workforce by taking a close look at our immigration rules? So this is very much in line with an executive order that was issued by President Trump at the very beginning of his term in 2017 called Buy American, Hire American. And what this proclamation does is it suspends entry of any individual for at least 60 days who's seeking to enter the U.S. from outside the U.S. as an immigrant. And I emphasize the outside the U.S. because there are many, many people in the United States that apply for permanent residence, immigrant visas, green cards, those are all the same thing, from within the U.S. But there is a percentage of people that apply from outside. An example might be parents of U.S. citizens residing abroad. In any case, for 60 days, these are suspended. And again, we have certain exemptions. Those who already have green cards, physicians and nurses and doctors who are coming in to combat COVID-19. And interestingly, individuals who are applying for visas to enter under the EB-5 Immigrant Investor Program. Some of you may be familiar with this program. It is, in general, where an individual can invest a substantial amount of capital in an investment in the U.S. and create jobs in the United States and thereby obtain permanent residence. So those are all exempt among several other classes of people. Another thing that was interesting about this last proclamation is the fact that it did not touch at all on temporary workers, people who are generally commonly called guest workers. It didn't exclude any of those people. It didn't limit their ability to come in during this 60-day period. However, It's worth noting that within the proclamation, the president requested that the Department of Labor and the various immigration agencies inside and outside the U.S. advise him within 30 days of the proclamation as to what types of measures could be taken to stimulate the U.S. economy by focusing more on these non-immigrant temporary workers in the United States. So this is something that we are expecting will come. It may come as early as May 23rd. What about entering other countries? While fewer people are traveling internationally due to the pandemic, it's clearly important, if you need to travel, to check the travel restrictions of each country. And just about every jurisdiction has imposed restrictions, and they really are all over the place. You have to check them day by day, country by country. But they range from a ban on admission to medical pre-screening to self-imposed quarantine for 14 days to prohibitions on all but essential travel. For example, on the north-south border of the US with Canada and Mexico, travel is essentially closed except for what is deemed essential. There's a pretty substantial group of what's deemed essential, and that does include people who are working in the United States or coming in for health-related reasons. We monitor these restrictions daily. We also engage with several global networks that our firm is actively involved with, so we know what's going on the ground, because as I mentioned, it's a very fluid situation. Let's talk a little bit now about the impact of the COVID-19 pandemic on those foreign nationals who are already here in the United States, people who found themselves here when the restrictions were imposed. Well, when the outbreak occurred, we received many inquiries as to whether U.S. Citizenship and Immigration Services was going to suspend all the deadlines, basically say, you know, we're waiving deadlines. If you're here, we'll excuse the fact that even though you might have had a deadline as to how long you could stay, you don't have to file anything, and we understand you can't leave. Well, that actually did not happen. And of course, this would affect tourists. It would also affect house staff, because many of the house staff work pursuant to specific work authorization documents, cards that give them temporary benefits to work for specific periods of time and require re-registration and extensions. So there's no blanket waivers, despite the fact that immigration has temporarily suspended all its in-person services until on or after June 4th. However, many applications are filed by mail, and immigration does continue to receive these applications. On the positive front, there's been some temporary flexibility for certain requirements. Take tourists, for example. Many people travel to the U.S. as tourists on what's called the Visa Waiver Program. It's also called ESTA. These are mainly people from European countries, but it covers 39 countries, and it allows people to come in for up to 90 days without a visa, basically. We have had a number of clients that found themselves here during the pandemic, and it was impossible for them to go back or meet the 90-day requirement. Some of them, their own countries even closed, and they weren't able to get out of the United States. Historically, it's been, I would say, almost impossible to get an extension of this kind of a tourist admission. There is a process for it, but it's sort of a life and death thing as to whether you can get it approved. Well, during the pandemic, U.S. Customs and Border Protection has come out with a policy to be flexible here, and they are granting extensions. They're called satisfactory departure in 30-day increments. So there's a process to do this. We've done a number of them. We just did one for somebody from Ireland who suffered from asthma and just was concerned about traveling. We had no problem. We have found them to be quite generous. It's very important, though, to apply under this process and not let the status lapse. Let's go on to domestic workers, and particularly for those of you who are in South Florida, you know that we have many, many domestic workers here who are from the Central American countries, and they work under specific grants of employment authorization for limited periods under a program called temporary protected status. Many of these people have been in the U.S. for over 20 years. In fact, there's over 400,000 of these people here in the United States. Well, there's no blanket extensions for these individuals either to extend their work authorization documents. And in fact, a number of these work authorization documents are about to expire in January, early January of 2021, which is really right around the corner. Just last week, several senators wrote to the president and asked him to provide automatic extensions of these documents. And we're hopeful that that will be approved. There's some precedent for this. It's been approved in certain situations in the past. But what's really important, if you do have House staff in this situation and they're concerned about their work authorization, is to consult with counsel. We are happy to help, just to see and follow this issue and see what's going to be required so they don't lose their legal status. It's also a good time to think about mapping out a long-term legal strategy for some of these individuals if you're in a situation where you'd like to help them remain in the United States. Well, what about private yacht passengers and crew and pilots for private aircraft? Some of our clients actually chose to wait out the pandemic at sea. And they were just sort of cruising around in the Caribbean and trying to find when would be the best time to go back to their home country, which was out of the US, and where would be the best place to dock. And this turned out to be pretty complex as things escalated and got more and more complicated. There was just an overlapping number of restrictions: state, local, health authority, Coast Guard, some immigration. And we looked into all of these and on a sort of day-by-day basis tried to monitor where would be the best place to disembark. So I would caution you that if you are aware of a vessel in this situation, or you have this situation, to be very careful looking at where to disembark, particularly for the crew, because many of them are often not U.S. workers. Now let's turn to employees, which is an area that we spend quite a lot of time on in our group. Many of you in family offices do employ professional employees in your businesses, and these individuals may be on sponsored work visas. You might not have had an opportunity to look at this before. We find many people don't really view their workforce as an international workforce, but if you look closely, you do have people working in finance, working in information technology, who are on temporary work visas. And these visas tend to be the visa that's called the H-1B, which is for professionals. This visa classification has a lot of limitations to it. It's monitored by the Department of Labor, and there are rules against furloughs. There's also rules regarding posting certain requirements to give notification of where the individual is going to be working and what's been filed. So with the advent of remote working, the Department of Labor has issued quite a lot of guidance on this, and we are currently advising employers in it. So I would tell you that if you have these people in your family office, or you might have them, double check and make sure that you're following the substantial guidance that's come out in the last couple of weeks. Finally, with respect to employment eligibility verification, your HR representatives in your family office typically are the ones that when you hire new people, or when some of your workers' employment authorization expires, they are required to re-verify the employment eligibility of those workers. This goes on in every U.S. business. It goes on in our law firm. It goes on. It's not just international businesses. Everybody must do this. So this has presented a bit of a dilemma, because HR representatives were either working remotely during the pandemic, or were definitely not comfortable touching the original documents that they are supposed to inspect for new hires, or just people that are working there whose work authorization needs to be re-verified because it's expiring. The government's put out some guidance on this, and there is some flexibility on it. In addition, some flexibility on identity documents that are expired, like driver's licenses, when people cannot renew them. And the last point I'm going to cover is this: what do we see in the future? You remember that I mentioned the most recent proclamation said that the various government agencies should report back to the president with measures that they thought could be taken to further stimulate the U.S. economy with respect to U.S. guest worker programs. Well, we see a hint of what may be coming with a letter that went to the president last week from 4 senators in which they urged a 60-day suspension of all new guest worker programs, followed by a 1-year suspension in certain categories. And these categories included the H-2B category, which covers non-agricultural seasonal workers, many who are in landscaping, horse grooms, for those of you that are potentially in the equestrian sector, your horse grooms may have the H-2B, and other seasonal workers. In addition, it calls for the suspension of the H-1B visas for these highly trained professionals as well, and to cut off the ability of foreign students who graduate from U.S. universities to work under what's called optional practical training for 1 to 3 years after graduation. So it's yet to be seen what's going to come out of this, but keep your ears open because something may be coming in the next 2 weeks. So just in closing, well, I've given you an overview of the U.S. immigration impact related to the COVID-19 pandemic. Keep in mind, it's a very fluid situation. These things are changing day by day, and it's really important to continue to be in touch with counsel to obtain the latest information. Thank you. And now I'm turning it back to Lisa to introduce Holly.
Thanks so much, Sarah. That was quite informative, a lot of information. I'd like to now introduce Holly Goodman. Holly is going to talk to us a little bit about how to interact with your domestic staff during this crisis and how to deal with having a home office. Holly?
Thank you, Lisa. So obviously one of the main concerns of businesses right now is issues that are pertaining to their employees with COVID-19, how to reduce the likelihood of transmission. For individuals who might have domestic staff who are coming into your home, obviously you likely have similar concerns, but only from the perspective of, yourself, keeping yourself and your family safe and protected, as well as your staff and preventing transmission amongst your own staff. When the coronavirus pandemic first got started, some of you may have requested that your staff not report to work. Others of you might have had your staff continuing to come into your home during this time. So right now what I want to do is give just a high-level review of some of the common questions that we receive about the obligations and liabilities of individuals as employers or of their companies as employers of domestic staff. If your staff has been out of the home, you do not have to allow them to return into your house and into your home and into their positions if you're not ready for it yet. If you do decide, or if you've been allowing them to come into your home, one thing to keep in mind is that there are some rights. You do have the right to ask them questions, given this pandemic, about their potential exposure. So you can ask your staff whether they're exhibiting a fever or a cough or one of the other symptoms of coronavirus that the CDC has identified, and then ask them to stay home if they do have those symptoms. One new thing that's going on right now that affects even employers of domestic staff is that one of the early congressional acts, the Family First Coronavirus Response Act, actually gave all employees the right to additional paid leave. The Federal Department of Labor clarified within the last week that this includes domestic staff. So if you have employees, housekeepers, cooks, or other employees who work within your home who are employed by you or by one of your entities directly, and they need time off because they've been advised to self-quarantine by their physician, or because they're exhibiting symptoms and they're seeking a diagnosis, or for one of several other enumerated reasons, they're actually entitled to paid leave, up to 2 weeks worth of paid leave. Full-time employees, that's 80 hours. For part-time employees, it's the average number of hours that they normally work. We do have more information about those requirements on our COVID-19 website that Lisa directed you to earlier. There's a little bit of a different concern than if you have a family office. And so if your family office has been closed by the governor's orders or is considering reopening right now as those orders are starting to lift, there are a few things that you should probably keep in mind. There's a lot of guidance being put out by the federal government right now from the Occupational Safety Health Administration, the OSHA, from the Centers for Disease Control, from the CDC, and then from the White House itself. So there's different phase information about what types of actions businesses should be taking as they're getting ready to reopen in order to protect their staff and prevent the transmission of coronavirus. Given all of the guidance that's been put out there, it will likely have created a new standard of care. So if you have a home office or a family office and will have people coming back into your family office to perform their jobs, we encourage you or somebody on your staff to look at the OSHA guidances, the CDC guidances, to see what recommendations you may need to put into place in your workplace. For instance, social distancing, moving desks away from one another, staggering start times for your employees, or having them alternate days in the office, or allowing employees to work from home if that's feasible for your business. A lot of these same requirements, of course, also apply for those of you who may own or run your own businesses, and it might be to an even greater extent depending on the number of employees you have reporting to you. And then one final piece that I want to touch on just briefly is a reminder that although we are in unusual circumstances, the standard employment laws also still apply. And so we are expecting to see questions and issues come up after the pandemic has ended about wage and hour, for instance. If employees have been working from home, you want to make sure that they're properly tracking their time and that they're being compensated appropriately. Our group is available. We are assisting businesses, employees, clients, well, not employees, businesses and clients with their employees on reopening and on advising regarding steps that you can take to try to minimize the likelihood of transmission in your workplace. If you have any questions, you can reach out to us or use the chat function. And with that, Lisa, I'll send it back to you.
Thanks so much, Holly. So now we're going to open it up to a couple of questions. We can try to keep the presentation to an hour as promised, so we have a few more minutes. So Elaine, this is a question for you. Does a sale to an IDIT, an irrevocable defective grantor trust, need to be reported on a gift tax return?
Great question. Technically, the answer is no, because the sale is not a gift. Now, that being said, we would recommend reporting a sale on a gift tax return in order to start the statute of limitations, the 3-year statute. One thing we'll do if we have the flexibility is perhaps do a gift in 1 year and a sale in the following year. The gift tax returns now have a box to check if you're taking a discount. And so to the extent that you're taking a discount with the gift, you need to check that box, which increases the audit risk. If it's a sale only, you don't need to check the box. And so often, if we have the flexibility, we'll do the sale in a following year so that we can report it on the gift tax return, start the statute of limitations, but we don't have to check the box.
So Elaine, as a follow-up question, do you need to get 2 appraisals if you are reporting the gift in 1 year and the sale in the other year? And is there a way around that?
So if you are, great question, if you are transferring with a discount, so you're transferring assets and you're taking a minority interest or lack of marketability discount, you are required to get an appraisal. One way to get around that is to make the gift on December 31st and do the sale on January 1, or something similar to that. So you don't need a new appraisal. But if you're really spacing it a year apart, then certainly you need a new appraisal.
Thanks, Elaine. We have another question. Would the reduction of the term of a family loan be a good reason for the modification of an existing loan to a lower interest rate? So I will answer that one. So the reduction of the term is certainly a good step to take. If there is a modification, you really need to look at all of the facts and circumstances surrounding the loan. There are other aspects of the loan that may be needed to take into consideration that may affect whether you feel that there should be additional security for the modification or whether perhaps a guarantee. There is no black letter law on what reduction in term would be appropriate or what modification to the loan terms would be appropriate. It really depends on the situation, but certainly reducing the term of a loan or making a principal payment in advance would be something that would be attractive to a lender. So we have another question for Holly. Holly, can you comment a little bit more on any steps the employer should take before reopening the home office? Is there anything to be super concerned about?
Sure. So I think both with your staff that's coming into your home and if you have staff that are working at a family office, some things that are pretty standard right now are either requiring or allowing staff to wear masks. Especially for those of you who have staff that are coming into your home, you may want to have them wearing masks and gloves while they're in your home. For the family office, it may just be masks are more appropriate. You want to make sure that desks are socially distant, so at least 6 feet away. Close down any office areas where people tend to congregate in groups, especially if it'll be a larger group. And so perhaps closing down either a kitchen or conference rooms, avoid having people come in, and really encourage people to take advantage of platforms where they can do video or telephone conferencing to try to avoid face-to-face meetings. So those are just a few ideas on things that you really want to be looking for. But you should really take a hard look at how your business operates, how your family office operates, and what steps you can implement to try to avoid face-to-face communications and being in close contact with one another.
Thanks, Holly. We're going to take one more question. And Elaine, I think this one's for you, Elaine. Can liquid assets be transferred to an irrevocable defective grantor trust at a discount?
So the answer is yes, if they are put into a family limited partnership or LLC. No, if they're just transferred straight to the intentionally defective grantor trust. And so one technique that we often use is to contribute liquid assets, marketable securities to a limited partnership, and then the grantor transfers limited partnership interests to the intentionally defective grantor trust, getting an appraisal of those limited partnership interests that show the lack of marketability and minority interest discount. And so a grantor can transfer 99% of the interests, but if they're limited partnership interests, then they are entitled to a discount, and the discount is going to be typically lower than if the assets were a closely held operating business or a family limited partnership with real estate, but still a nice size discount, 30 to 35% is what we're seeing. So the answer is yes, if it's done properly.
Thanks, Elaine. Well, I think we are coming to the end of our program. If you have any other questions or if any of your questions were not answered, we will do our best to respond to them. And as I said earlier, you can certainly continue to submit questions, and the presentation will be available tomorrow morning on our website. I would thank all of our speakers today. Appreciate all the information that everyone has shared. Thank you all for attending our presentation. We hope that you all stay safe, stay secure, and continue to to navigate the uncertainty that we're all facing. If we can help in any other way, please let us know, and thank you so much.